It is your lordship. So we are filing an appeal on behalf of SEBI lordship. We are filing. I'm praying for its listing tomorrow. There is a ramification pan India lordship of this judgment, which is being challenged.
File it.
It is in. We have received the filing number. It is in the process of filing. Within 20 minutes, it will be filed.
Tomorrow. Tomorrow.
Deeply obliged, lordship.
Okay, lordship, please. Because I'm mentioning a fresh writ appeal which is being filed. So this is a matter which has been filed on behalf of GAIL India Limited and relates to a pipeline of national importance. Now, they are seeking some interim relief in the matter. I'm requesting that it be listed tomorrow. It's yet to be registered.
If it is not registered, we will not. That is what we are asking to learned advocate general.
If it will be registered, it is
Then
filed.
counsel you file it tomorrow. Mention it again.
If it is registered today, then I'll mention tomorrow.
Great. May I please, Lordship, with the consent of other side, Lordship, I pray, Lordship, item number 2 may kindly may deferment after vacation.
Item number?
2, my lord. Here, my lord, we would like to bring on record certain documents, my lord.
No, we will not extend the matter. Sorry.
Wait, please. Item number 21 of today's list, my lord. We are praying for some accommodation for today. Item number 21. 21, my lord. We are for the Mizoram University, my lord. Let it be after vacation. In the meantime, we'll file an affidavit, my lord.
Next.
Obliged.
I hope you inform the other side. Otherwise,
We
then
have taken the consent of Mr. Silo, who is for the
yesterday
other
somebody
side.
mentioned about it. Therefore,
We have taken the consent. Obliged.
May it please your lordship. I'm making a prayer for listing of a writ appeal on Friday, my lord. We have filed it today and we have received the filing number also, my lord.
what is the matter about?
My lord, it is a my lord, no confidence motion, my lord.
That can wait. Next.
My lord,
Not that urgent.
my lord, my lord, may I submit, my lord, on 16/10/2022, my lord, direction was given to hold a fresh meeting. Although, my lord, my repetition was allowed. So that is where we are agreed, my lord.
Come after puja. Next. It is not an
I'd
urgent.
like to mention item number 15, my lord. Matter may be list after vacation.
Item number?
15, my lord. What?
Next.
May I please, your lordship, I am on behalf of Digos. I beg to mention item 16 of the daily list. Lordship. We have
16?
taken, yes, lordship. We have taken consent from the other side also. Lordship, this matter may be adjourned for 6 weeks.
What?
6 weeks. Lordship.
That pollution matter.
Yes, Lord.
You have to file the reply.
Yes, Lordship. We are collecting
File
some
it.
more data.
Next.
Deeply obliged, Lordship.
May it please your lordship. My lord, in regard to item number 17 of today's list, we have entered appearance recently on behalf of respondent number 4. We seek some time to file our affidavit in opposition. Can this matter be taken up after puja?
Have you informed
I
the
have
petitioner?
informed the other side councillors.
Next. Call out.
Deeply obliged.
All Mr. Cohen. Notice returnable on 9th November. Next.
May I pray for interim prayer, Lordship?
Next. In PIL.
Lordship.
You can pray anything, but we can't grant everything.
Lordship, in
You
the
want,
meantime,
we may refuse it. If you want to, we may refuse it.
like
Next.
May I please, Lordship? Initially, I make a mention, my lord, in this.
This is against an interim order. Go and file application before the learned single judge.
That writ petition has been disposed of, my lord.
That writ petition is disposed of, my lord.
Then
It's-
what
My
remains?
lord, the question is that, my lord, about this particular provision, my lord.
That is see, what you have challenged in this.
My lord, page 6, my lord. Paragraph 6, my lord.
No. Which order are you challenging.
My lord, order, my lord, basically, my lord, we have been affected by virtue of the, my lord, compounding action that has been contemplated by the authority, my lord.
Hmm.
And that action has been contemplated in the light of the amended part, which is otherwise contrary to the existence earlier law, my lord. There are two laws still in existence, my lord. One is non-compoundable, and in another way, my lord,
Therefore, see, I told you last time
my lord.
that there is a thin line of difference between irregular and illegal.
My lord, my lord,
Now, there are in a master plan, there are zones.
my lord.
Once it falls within the commercial zone, then the bifurcation of restaurant, a shop
My lord,
is not there.
my lord,
Then it comes within the purview of permissible use,
my lord.
and you just put a prayer of virus and then come before the division bench like this.
My lord, kindly see, one aspect
Ah.
is very important. My lord, the once still in a law, there is a situation where, well, let's just look for one paragraph 6, my lord. There is change of use is treated as a non-compoundable item.
No. Therefore, Mr. Counsel, whether that change of use is permissible or not,
My lord,
what has it to do with this virus of this action,
my lord.
constitutional validity of this action?
My lord, question is that, my lord, that the change of use entirely, my lord, change. the
Therefore,
basic-
we don't see that there is any violation of Article 14 or 16 in this.
My lord,
Go before the learned single judge. We don't mind. You may fight out.
my lord, no doubt.
Ah, then exhaust that.
My
Ah.
lord, that part we have, my lord, already.
Are you aware about that Onida's old advertisement? Onida TV.
Yes.
Do you know this slogan or you have forgotten? Owner's envy and neighbor's pride.
My lord,
But you have reversed it. We can understand that.
my lord.
For that virus is not to be examined. Any matter, you come with a virus challenge and address us on division bench.
Can we see that so far the Article 14 is concerned, my lord, that whether it has
Therefore,
been-
we will deal with Article 14 today and send you back to the learned single judge.
my lord.
Every act cannot be
No
examined
doubt,
in
my
this
lord.
manner.
Quite right, lord, it's quite right.
Go before the learned single judge. We don't want to stop you. Forgo the virus problem.
Well.
Heard Mr. S. Tamaria. And so for the respondent. Mr. Tamaria does not press the prayer of constitutional validity of the as prayed for in para 19 of the prayer clause. The rest of the prayer be considered by the appropriate bench of the learned single judge. It will be open for the petitioner to amend the petition
Well.
if found necessary.
Well.
Next. Yes, could you get the
Yes.
instructions? Are you going to do anything with the land?
Lordship, in fact, I think this is a case of hut burning. Now, what has happened here is, Lordship, as per my instructions, for temporarily for 4-5 days, the authority came and there is a that's a memorandum in support of that.
Mr. Chaudhary, his worry is that you are bound by your own rules.
Yes, we are doing it as per our rules.
Have you given an option notice for that?
The rule that he is referring to, Lordship, that is not applicable here.
Because you want to say that there is some discretion in the officer concerned to give it.
No, it's not like that.
Huh.
For social functions, for religious functions, on an application made by a employee of
Yes.
the railways, the railway authorities can consider it.
Employee,
Yes,
not to an outsider.
no, he has to be a railway employee and there is a application which has been considered and permission has been given for 5 days, 1 to 5.
No, but if you see the petition,
Lordship,
who are these respondent 8 and 9? They are
8 and 9, Lordship,
so you are not giving to 8 and 9.
I'm not giving to 8 and 9,
Then the
Lordship.
matter ends there, sir. They are not giving to
No,
8
my
and
lord.
9.
With your permission, my lord, I would like to submit something. My lord. My lord, there are two aspects, my lord. One thing is, my lord, that permission has been granted for conducting puja and rituals, my lord.
Sir, you turn to page 4 of your petition.
Point number 4, my lord.
Paragraph 4 of your petition, sir, at page 9. The petitioner begs to state that the persons, bodies, institutions likely to be affected, so and so, respond number 8 and 9, and the officials of the railway department.
Yes, my lord.
Now, who are you?
My lord, here, my lord, the petitioner filed a.
No, who are you?
He himself says he was a member of that committee.
No,
earlier.
my lord, earlier.
No, who are you?
My lord, I am representing the public as a large, my lord.
Public, so 12 lakhs are there, including me now.
My lord, here the main.
You are working in a government concern, or a government.
Yes, my lord. My lord, here is a loss of public exchequer is going on, my lord.
There is no loss.
My lord, actually the purpose.
You filed the
That lordship, the fees has been levied.
you file the affidavit by day
Yes,
after
my lord.
tomorrow.
My lord, permission has been granted for ritual, not for
Next.
commercial usage, my lord.
Next. Mr. R.K.D. Chaudhary, learned Deputy Solicitor General, to file affidavit by tomorrow.
Lordship.
Extend to Friday. But we'll examine it.
Yes.
What is the post that you occupy in government?
My lord, he's a nodal officer, my lord.
Nodal officer. So grade 2 or 1?
That I will have to take.
Please inquire by Friday.
All right.
Next.
May it be your worships. This matter relates to
Mr. Chaudhary, any evidence on you attending the school is there with you?
In fact, my lord, the evidence could not be, my lord, produced before the honorable single.
No,
My submission before your lordship will be that, my lord. By a decision of the full bench of the honorable court, this type of matters regarding provisional action has to be taken up by the, my lord, education tribunal. My prayer before your lordship will be that, my lord, I should be given liberty to approach the tribunal
there.
so that, my lord, I can reduce the evidence there.
Go there, because that is the crux of the whole matter.
Yes, my lord. Because, my lord, there are disputed questions of fact.
Yes, Mr. Majmudar. Which is the judgment of the full bench. We have also passed one such order in my. No, I think we have also passed one order.
One order has been passed. But I'll have it.
We'll pass appropriate order.
May I take the decision of the my lord, full bench decision?
We have relied upon it, and we have also taken that view.
My lord.
You can pass it over judgment for our convenience.
My lord. Obliged.
Next.
Obliged.
Your lordship may just tell you, my lord, the order that 4122 passed by your lord.
Yes.
In this matter.
Refund.
Yes. 4122.
Yes, read Mr. Saival.
Look, the petitioner was the option passenger in option cell and his bid was fully accepted by the option.
Therefore, in short, either you get the money back or the possession. That
anything, my lord, because I have paid.
Common substance is that.
Yes, my lord.
Whether you read any order. Yes, so you appear for the bench?
Yes, your lord.
What have you to say?
Your lordship, that on 29/4/2016, that is annexure 4 at page number 21, we have already issued the sale certificate. And
No, you put him in possession. You put him in possession. We are not in. They are not disputing anything.
no,
See, your sale certificate should not sound like your NPA. These are only on paper.
yes, your lord.
So give possession. Otherwise, you give back the money with interest. Because you don't leave even 1 day's interest.
No, your lordship, what was happened that
Anything has happened, sir. Common substance is this.
your lordship, but the writ petitioner has come up before us only for taking the possession in the year of 2018.
Here limitation will not apply.
No, I am not saying that the
Either
limitation will not
you
apply.
pay money back. You are You have ample money. They are citizens.
Your lordship, the problem is that we have already adjusted the money with the account.
No. Money with the account is adjusted with the borrower. He is not your borrower. He paid and you adjusted. Then he is entitled to for that. We will not relegate him to filing a civil suit.
Your lordship,
Either pay the amount with interest, simple interest. We don't want that those jargons of your house loan or home car loan. Simple interest, or give the possession.
But your lordship, the respondent number 2 has filed a civil suit.
That we are not concerned. See, even in SURFACE, the basic law will apply. Buyers beware is the principle which has to be followed as far as the appellant, the petitioner is concerned.
Yes, your lordship.
But the question is that when the sale is complete, it is bound on duty of the seller to hand over the possession. Otherwise, you can't have the sale price. You take the sale price
Only one submission, your lordship.
and go wherever you want to with your borrower.
Only one submission, your lordship. That is at page number 21, your lordship.
Read.
That is there, it has been written that when we have issued the sale certificate in the year of 2016, that is there, it has been written that the possession has been handed over.
You show us.
Yes, your lordship. Yes, I am coming to that. your
Mr.
lordship.
Sharma,
Thereafter,
I may tell you, don't make an attempt to take it to a point of disputed question of fact. Because these are surfaces.
yes, sir.
Please don't make that attempt. Your manager or your bank will be in problem.
Your lordship, a date may be given for the type of appropriate instance.
Don't compel us to tell you that it is cheating.
Your
Yes,
lordship,
defined
but
under
they
IPC.
have come up after 2 years.
They may come after 10 years. Have you taken money from him or not? Was he your borrower?
No, your.
Then?
Is the option, but
Then nobody will trust bank under surface if you keep this type of behavior. Next. It has to be evenly balanced, this NPA, economy, everything. But bank managers can be permitted to be land dealer like this. Tell them to find out a way out, commercially viable. Next. Yes, Mr. Manta.
Lord, here the challenge relates to section 159 of the RP Act. On the last occasion, Lordship wanted the central government to respond.
Lordship, in fact, I have communicated, Lordship, response is coming. Lordship, can we fix it after the vacation, Lordship? In the meantime, I'll provide.
Mr. Manta,
My lord.
I distinctly remember there is one judgment on LIC.
LIC.
LIC employee.
LIC employee, I have verified, they have checked up. There are decisions, and that is the decision Lordship might be aware about that St. Mary's School.
St. Mary's School is a different issue.
And also in the bank matter, the apex court has said, no, you cannot. You cannot. LIC also, it is central government institution, therefore.
Ask number.
And probably this went to the Honorable Apex Court and it was confirmed. Probably.
Let's fix a date so that they can meanwhile file it. And we can also respond to it if necessary. And then it can be hard.
Because nobody is in hurry. It has become academic as such. Now
Yes,
elections will come in 24.
It is causing severe harm to the institution. They draft as a whole, almost more than 60% every time. And
Maybe
even for
anything-
Panchayat election also.
Mr. Mahanta, when they want any benefit of being a government servant, they say that we are government servants. When government tries to take work as a government servant, they say that no. This is hit by 159. That is also there.
Well,
Ah.
true, but then at the same time,
They-
balance has to
For
be
example, in census, it is a known fact that teachers, even as a child, I have seen it. Teachers used to come to our houses.
Yes.
So they are not sacrosanct, but
True.
we will
true.
examine. It's
we
an
are
important
not
question.
saying, we are not saying that cannot do it.
Ah.
But there has to be some,
When they want
guideline.
seventh pay commission, they say that no, we are government servants, so pay us 7 pay servants. They want provincialism, we are government servants. But when it comes to duty, they say that no, 159 is it.
no.
This is my view. But we'll examine.
Lordship will kindly examine.
When I
The
get
other side
benefit of your
also.
hearing.
We are also doing the same duty for the institution. This is also not-
Naturally, we can understand that they request Mr. Sahewal to send some advocate for this duty, then it is understandable.
Therefore, it has to be balanced.
You are paid from the state exchequer.
True.
Ah.
True. Therefore, they are
Not
charging
from
their duty to the
consolidated
state
fund.
only.
Therefore, Mr. Manta, they are not paid from Consolidated Fund of India.
No,
They are paid from state exchequer.
true.
So that is the difference here.
Well,
It's an
true.
interesting matter.
I'm grateful for your lordship's, your lordship has expressed, but we will have to strike a balance, my lord, so that the institutions, all the organs can function.
Yes. Balance.
That is the,
See, it has to be balanced.
yes.
It has to be balanced, not only balanced for the timings, but balanced for the type of duties also.
Exactly, my lord.
Ah.
That is,
To ask an headmaster to go and distribute the sleep, we can understand. But that can be worked out with ECI.
true, my lord, that has not been done,
It has to be done.
that has to be done. That is my
Mr. Chaudhary-
basic point.
This is meant for Mr. Chaudhary, not for you. Next.
Deeply obliged. Oh.
In this case, my lord, earlier I prayed for implement some respondent, my lord. I have already filed party implement petition, my lord, but it is not in record, my lord. So may I pray, my lord, this IMAB.
Who is for the respondent?
My lord, I am for the private respondents 1 to 30, my lord.
Private respondents, you are there.
1 to 30, the original response.
We'll admit the writ appeal for hearing.
My.
Such a award is unknown to at least the Land Acquisition Act. In fact, when we read for the first time, we may tell you, we were thinking to post the order and send the proceedings back to the learned single. It just can't be done. But
Order
we hear you. Appeal requires consideration. The same is admitted for hearing.
And order is state, my lord.
Respective advocates waive for the respondent. Next. And in IA, till the appeal is heard, there is an interim order already there, isn't it?
No.
The judgment and order is there. Next.
May it please, Lordship, this is a challenge to judgment dated 13/5/2022. Lordship, the case relates to compassionate appointment. Lordship, the petitioner's father died, Lordship, out of a medical condition.
No, but that is a person who dies because of medical condition. Means it's a natural death.
No, Lordship, he took retirement due to his medical condition.
Therefore, it
And
is a
therefore,
natural,
after 6 months, he died.
natural death. It would not amount to die in harness.
No, Lordship,
You
there
are
are
not in service.
no, there are, as part of policy also, there are 3 conditions for considering compassionate appointment. One is die in harness, one is missing, and other is a medical condition, prematurely retiring medical condition. However, 2 conditions needs to be fulfilled. If Lordship sees the policy,
At,
Now
at
read-
page 75,
You read para 12 of the judgment.
yes, Lord. Yes, Lord. Lordship, yes, Lordship, I took yes, a reading of the application dated so and so and order dated 2/1/2015 makes it amply clear that the petitioner's father was allowed to go on voluntary retirement under FR 56, which provides that any government servant may, by giving notice of not less than three months in writing to the appropriate authority, retire from service after he attains the age of 55 years or 25 years, whenever is earlier. The order dated 2/5/2003 nowhere states that the petitioner father retired prematurely from service on health ground. The medical certificate relied on the petitioner cannot be said to be a medical certificate issued by the state level standing medical board as prescribed under the scheme, nor it is a case of the petitioner that his father was receiving invalid pension under rules 82 of the Assam pension rules. 1969, none of the criteria prescribed in the OM dated 1/6/2015 therefore supports the case of the petitioner to be appointed on compassionate ground. The
Now-
court,
Now go to the OM of 2015.
yes, Lordship, my case is I am not finding any fault in the judgment. My only case is that after there was a query of the learned single judge that whether I have been sent to the medical board or who was the authority to send us to the medical board. Now, for the first time in this appeal, respondent number 6 has filed an affidavit giving some light, and I have also filed a reply giving a document which suggests that they wanted me to place before the medical board. Lordship. This is for the first time.
They are trying to help you. Now go to page 109, para 5. Para
Yes,
4 of your affidavit in reply. This is further to be mentioned here that as per OM issued by transfer for appointment on commerce, there is no provision in the rules for a son, daughter, or brother who voluntarily retires from so and so. So what is the reply to this?
no, Lordship, I have replied. There is one affidavit filed by respondent
No, no,
number
you-
6.
You please read. They have annexed the OM.
Yes,
Starts at page 111.
yes, Lord.
Then last paragraph 2, dependent family member means the person who was only dependent on, we may not examine that, but whether a retired person also, son also should be considered after his death.
Yes. Lordship, I was just praying to consider it as equitably. Lordship, it is
No, no, equity, we can't bend the rules in service matters. We can't be kamashas here.
Lordship, and another thing, the whole provision, I was arguing that it is directory in
Mr.
nature.
Counsel, these are all, maybe we don't want to examine directory or mandatory. It's not our jurisdiction. You have to go as per OM. If the OM says you are qualified, you get in. If the OM says son of a voluntarily retired person cannot be considered for compensatory appointment, the matter ends there. We can't extend that scheme.
Lordship, very, very correct, Lordship, but there is
These are
no
the rules of the
restriction as
scheme-
such.
Scheme for compensatory appointment. We can't bend it as per convenience.
No,
Who appears
Lordship,
for
there
the
is no
government?
restriction as such for voluntary retirement. If it
Who appears
furthers
for
the
government?
object and scheme of the scheme,
Who appears for the government?
Lordship, I am appearing.
What is your say?
Lordship, we already have stated in our affidavit, Lordship, that
Hmm.
the person has retired, has taken voluntary retirement on medical condition,
Hmm.
but he was asked to face a medical board, Lordship, but
For what
instead
purpose?
he has obtained a certificate of his own, Lordship, and produced before
No,
the
for what purpose medical?
Lordship. He has some ailments, Lordship. This is not properly.
No, but his ailment has what has it to do with his qualification for compensatory appointment?
Lordship.
Compensatory appointment is based on he being son or daughter or dependent of a government
Or
servant who
government
has
servant,
died in
Lordship.
harness.
Lordship.
That you have to tackle. Sending him to medical, we are not concerned with that.
Lordship.
You show us from the OM that whether a voluntarily retired person's son or a dependent can be considered after his death for compensatory appointment. We didn't find anything. Do you understand
Lordship.
what we want?
Lordship, the affidavit in opposition filed by the respondent number 1, Lordship.
It does not contain, otherwise you would not have asked you, you would have told you.
Lordship.
It does not contain that. That is what I was showing it to him at page 119. If you read para 4, which I was asking him to reconsider the case of the appellant, but could not recommend the name of so-and-so for the post of constable as his father had voluntarily retired on his own. It is further to be mentioned that as per OM dated 1/6/2015 for appointment on compensation, there is no provision in the rules for a son who voluntarily retired. You show us from that annexure 1, which is annexed by you.
The OM, Lordship.
OM is there as annexure.
Yes, Lordship. In the first page, the last one, 2 dependent family members, Lordship. In the OM dated 1st June 2015, Lordship.
Was only
Dependent
on
family
government
members
servant
means a person who was wholly dependent on the government servant at the time of his death in harness or retirement on medical grounds or missing as
Therefore,
the case may
on
be.
the contrary, he is included in that. That category, that is why I was asking him to read, but he could not catch me.
Lordship.
Then you have to consider.
Yes, your Lordship, directly.
No, you take proper instructions. We don't want to impose our reading.
Lordship.
His category
Lordship.
is to be considered for compensatory appointment. Therefore, your version that who voluntarily retires from service
Lordship.
to apply is a wrong affidavit.
Lordship. Lordship.
I don't know whether
But-
you have drafted it or your para-wise remarks compel you to file this affidavit without reading.
Lordship,
close to.
Lordship, the main ground that is taken by the respondent is that the person has taken the voluntary retirement on his own request, Lordship.
Maybe, but on medical grounds, you see, retirement is not defined
Lordship.
in OM of
Lordship.
2014.
Lordship.
Therefore, it is by way of superannuation or voluntary is not the difference.
Lordship.
Otherwise, you would have said that
Yes,
superannuation.
Lordship. Yes, Lordship. But that particulars, this specific query, Lordship has put Lordship. I may be allowed, Lordship may fix it immediately after the vacation and I can.
20 October at the request of Ms.
Lordship.
Bhattacharya.
Deeply,
You also examine, this is in your favor.
deeply obliged.
Next.
Deeply.
कोई ताकि भी नहीं है। तो हाँ। Yes, Mr. Chaudhary, you were to take.
Yes, Lordship. The main plank of Lordship, the appellant's argument is in one particular case, the detainee was allowed to go to a refugee camp. That is one of the stands taken here. When I got it clarified, now what has happened was the instructions given to the learned additional Solicitor General that was misinterpreted. And now the review petition has been filed to correct that aspect of the matter. So, Lordship, perhaps that he was sent to a refugee camp may not be taken into consideration now. As it is, Lordship, the central government would not have any problem if he is transferred from one refugee camp to one detention camp center to another detention center, be it in Kashmir also. That's not an issue with the central government, but to a refugee camp means he gets more freedom. He gets more freedom, and that is not permissible under the provisions, Lordship. But if the state government of Assam and the state government of Kashmir, they agree, then he can be transferred from Assam detention center to a detention center in Kashmir.
Ms. Bhattacharya ji, ask your home department to take.
Lordship, as your lordship has asked me, Joint Secretary to the Home is present. Lord.
What is your say?
As of now, there is no policy to transfer the people from one sector to the transit. The policy matter. Policy decided it is better than.
No, we can't deal. We don't decide the policies here. You have to spell out. You have to take a decision and tell us. That is why we called you. Otherwise, you have army of advocates, government advocates. Why should we call you?
That we are bounded by the competent authorities to voters.
No, we
Pass the certainly we follow.
you examine and tell us what Mr. Chaudhary is saying.
Lordship may see the third page of the compilation, Lordship, at paragraph 8, which
Yes, para 8 is there. But the learned officer may not be aware about it.
Lordship, I will definitely.
You give a
I
one
will
set.
furnish him a copy. I'll furnish him a copy.
We do one thing.
Lordship.
You give one set to learned council also. If,
I think.
oh, it is the government council.
Lordship.
Later examine and tell us next time.
Yeah.
We keep immediately after reopening.
Lordship.
1st of November.
My lord, in the meantime, may I kindly take your lordship to a judgment of the Telangana High Court?
Piecemeal hearing every time we are trying to find out a way out.
Yes, my
Every
lord.
time don't insist for judgment. We are trying to find out a way out. And I am also aware that a similar issue is pending before the Honorable Apex Court also.
Yes, my lord.
I am conscious about it. Therefore, we have to be very careful. Even otherwise, these are all detention. Next.
I appeal for respondent matter. Petitioner challenge the order that matter 21/6/22.
Yes. He need not remain present. But he will have to brief you properly. Sorry.
Here at the petitioner matter challenge the order that 21/6/2022 matter page number 96 matter. He was removed from service matter. And so far matter to enquiries concerned matter in the enquiry as well as in the affidavit reply in the proceeding, he has admitted his guilt matter.
But you are Mr. Roy.
No, I am appealing from Mr. Roy. As what?
Let the other side be here.
After company.
Pass over.
Lordship.
What
In
is
the
the
earlier question, Lordship, so there was a similar matter where the Lordship was supposed to pass in judgment. And this would be covered by that. Therefore, Lordship had deferred this matter.
you examine our judgment and tell us?
Lordship.
You can examine our judgment and tell us.
Lordship,
There is already a judgment.
We'll give you the copy.
Lordship.
We'll furnish you the copy, you examine and see.
Yes, yes.
On the other hand, my lord, they have also accepted the judgment and filed an IA for extension of time, my lord.
We will give you, we'll provide you the number also. No, no problem.
Lordship.
Next. 9th November.
May I appeal your lordship?
What is the status? What is the status here, Mr. Majmudar?
My lord, they had prayed for effectuating their promotions out of what they call a select list and what we call a gradation list, which is yet to receive the approval of the WPT and DC department on the field of reservation. Writ petition was dismissed as being premature.
Yes.
Because nothing had finalized till then, there was no advertisement.
No, but
the
then you have
process of promotion has been initiated. He's in appeal, my lord, right?
We have seen the last paragraph of the impugned judgment,
My lord.
but this is of June. We are in exactly 3 months have passed. What is the?
My lord, my today morning's verbal instruction was that the WPT and BC department, the gradation list, the reservation has not been approved by the WPT and BC as of today, my lord. So they will be taking up the matter again with the WPT and BC. Once the gradation list is approved, then the
No, whether
process
you
for
approve
promotion
it
will
or
be started.
whether you approve it or you don't approve it, you have to take a decision. Otherwise, it can't be said that it is premature.
This process for selection for headmasters has
agree,
not
but-
yet been.
Mr. Majmudar, but you can't sit tight over it like this and take advantage of the fact that it is premature.
We are not sitting tight because the honorable court has said had said
You
it is
mean
premature.
the government.
We are processing the matter. Once the gradation list is finalized, it is only then, my lord, we can.
I am conscious about that
My lord,
procedure by now. You are also government.
my lord.
Then tell your secretary to take this decision
We'll do
immediately.
it. We'll take it. We have taken it today also. I had a discussion with them. They are processing the matter.
Let them take decision. Let us take at the request of Mr. R. Majmudar. 10th of November. Next.
Deeply obliged.
Obliged.
Please, Lordship. Resolution process was
I am appearing for the
initiated.
respondent, madam.
This is an ad interim order. Go before the learned single judge, and if you want vacation of the interim relief, file proper application.
My lord, no doubt, my lord, we can file it out, my lord.
You
Subject to
can
lordship.
take one latest judgment of the Supreme Court with you.
Yes, my lord, my lord, what my submission.
Therefore, whatever you want to say, tell learned single judge. You can file appropriate reply also.
My lord, the thing is that my lord, has only one, my lord, important aspect is that, my lord, the case was projected, the last limit is to 70 days, my lord.
We are not on that. It is clear-cut interpretation of section 12.
My lord.
Now, the learned single judge second extension which was granted.
My lord.
Their case is that as per the first proviso,
Extended seat.
only one seat is done. Once and no more.
My lord.
Therefore, you may face to argue in your own manner before the learned single judge. You have come immediately after the receipt of the notice by this court. Take proceedings before the learned single.
My lord, we can approach, my lord, only one aspect, my lord, which is important to lordship. Lordship, just allow me to submit, my lord. My lord, the Supreme Court, the Honorable Supreme Court clearly says, my lord, that no doubt, my lord, there is a bar that interim order cannot be, my lord, challenged before this honorable form, my lord, before the appellate jurisdiction. But question is that, my lord, here is a case, my lord, why the part of amendment was not mentioned, my lord, but the petitioner itself, my lord, is not the case of, my lord, abuse of the due process of law, my lord, to get, my lord, just the thing in a, my lord, in their favor.
Therefore, you please show it to learned single judge.
No.
This is an ad interim order. We don't find even otherwise. First proviso will have to be interpreted.
My lord.
Heard Mr. S. Chamaria. Do you press the appeal or we give you liberty to approach the learned single judge for the appellant? And Mr. B. Saraf.
A. Saraf.
A. Saraf. It is difficult to. I'm sorry.
No, Saraf is sufficient.
A. Saraf for the learned senior counsel assisted by so. Are you on a caveat?
No, I'm not filed caveat, but I was same type of.
For the original petitioner. Yes, this is an appeal filed against as such an ad interim order. When the appellant was not a party, Mr. Chamaria does not press this appeal with the liberty to take all available contentions before the learned single judge. It goes without saying that it would be open for the appellant to file appropriate application, interim application before the learned single judge. Next.
My lord, may I make only one observation if lordship, my lord, because this time limit by this 3:30 we have to complete. Lordship, that expedite, my lord, that the matter, whatever
What?
it is. will-
Arey, you have to go there. We have not to go. Mr. Saraf, one thing, now the matter is over, we have, therefore, probably your AOR has quoted this section from the old book.
No, that was pointed out to the court also.
No, but it is not in good taste.
No, I put it, look, that
But
was,
he must have, it happens. These bare acts are very dangerous.
in fact, I agree. In the court proceedings when it was there, when it was come to notice, it was pointed out to the court also.
I take it that it must have been pointed out.
But otherwise,
But
there
not-
was no intention.
No, Mr. Saraf, I am not for intention. The question is that you will have to ultimately amend the petition. Please see that your AOR amends it. Otherwise, it will go.
No, we'll do it, because that day itself I found the earlier, but
I understand.
nowadays every year, the barrack has to be different. Otherwise, so many changes are there. I will get amend the petition.
Next. It is also an interim order.
Shifting, merger and transfer.
Sir, this is also an interim order.
No, only for the interim.
Go before the learned people.
No, only thing, my lord. If your lordship kindly comes to page number 44 for one moment, my lord, just for one moment. It says, my lord, second paragraph, my lord. The Assam Gramin Vikas Bank Dakshin Debostan branch provides a range of financial services to the customers like widow pension, old age pension, PMAY, Arunodaya, and other schemes. It also offers a set of conventional schemes which most of the banks in India offer. The people of Debostan will be deprived of all these services if the bank is shifted from Dakshin Debostan to Howrah Ghat. Only to that limited extent, my lord. Let these widows and let these old age pensioners not suffer till the final adjudication of the writ petition, my lord. Only to that extent this writ appeal has been preferred, my lord.
Next. Do you want an order?
No, that is only till the final adjudication I am praying for that.
This system of changing the lobbies, I will not encourage. To be precise, it is not advisable for all of us.
I'll leave it up to your lordship, my lord. Only for the benefit of this old age
No,
pensioner.
therefore, for that you can file a request before the learned single judge. Nobody prevents you.
But we have filed, my lord. We have prayed before that, but the learned single judge refused the interim protection, my lord.
No, you can file an IO only limited to that extent.
That prayer was already made before the learned single judge.
That prayer was there for stay of the transfer in toto.
Or to maintain status quo. It is there, my lord.
What do we understand by maintain status quo?
My lord, because at the time of filing of the writ petition,
Therefore, did you point out with a prayer which you are pointing out to me?
we had pointed out, my lord.
Then you go before the learned single.
It was not considered, and that is why we are before the division bench.
Lekho, third master, so and so. For the appellant. By way of this intra-court appeal,
we need the prayer.
The applicant has, the appellant has challenged the order dated 22/9/2022, wherein the learned single judge has already issued notice and made it returnable after 6 weeks. From the order implemented, we don't find that there is any mention about the interim relief or consideration of thereof. Either the present appeal is filed as an afterthought or to surpass the jurisdiction of learned single judge, which cannot be permitted. The learned counsel appearing for the appellant vehemently submitted that in the prayer prayed for, we have prayed for interim relief which has not been considered. We do not find any such ever meant, even contention taken before the learned single judge while arguing for the admission of the writ petition. As the learned single judge is seized of the matter, we deem it fit not to interfere with the order of notice. It is open for the applicant appellant to approach the learned single judge for any interim relief.
The prayer for interim is at page number 85, my lord.
That is what we have noted.
Liberty may be granted to renew the.
We have granted you liberty. Next.
Obliged. Deeply obliged.
Next. Services.
Services are complete, my lord. They had appeared on the last occasion. All have appeared on the last occasion.
Kindly pass over for the time.
You file your reply.
My lord, I have filed an interim reply yesterday. It is not on record, my lord.
No. You are for the respondent.
I'm for the sorry, my lord. They have not filed. Yes, your lord. They have not filed. Sorry, my lord.
Your additional affidavit is.
Additional affidavit I have filed.
You file your reply. File your reply.
My lord, we'll have it.
Interim relief to continue.
My lord, only thing is that I had that additional affidavit why I had filed. In spite of that interim relief, they have not allowed me to join, my lord. They are not allowed me to work, my lord.
We have read that, therefore we are passing this order. Otherwise, it was unlimited. Next.
Much obliged.
Mr. Who is going to file reply, Mr. Majmudar, you or?
The railway.
The railways, my lord, the council is on legs, my lord. I'll inform him right now. He had asked me for a passport. Lordship of passport. I'll inform right now.
Much obliged.
So next, any date after puja? Follow. Yes, Mr.
But I had a detailed discussion with both the officers, SP and the IO. But they have given me a status report. Lordship has directed to complete the investigation. They have, in fact, in detail, the investigation they have started. Now the DSP is looking after the matter. The W2 messages are sent to the police stations, and also they are doing, but they could not complete it. They have given a report.
When are they going to complete? Now they must have come back from Kaziranga also.
No. In fact, they are doing it. I had a detailed discussion. Kindly keep the matter after the vacation.
19th.
After
19th.
19th.
First day, inform us that it is over. At the request of Mr. P. Nath. Yes, so to 19.
Can it be on 21st? On 19th, I may have some difficulty.
21st.
21st.
21st. It is Friday, probably.
It's Friday.
Next. You appear for Central Bank?
Yes, sir. I may allow some more time to file affidavit.
For what?
Your Lordship, on last date that Your Lordship has said that I need to file some affidavit because there was no explanation.
Yes. File it then.
Yes, Your Lord. Some more time.
Next.
This PL is against the installation of a wine shop near to a school and adjacent to the.
They have filed their reply.
My lord, they have filed reply and we have also filed an IA. My lord, their affidavit disclosed that the license is already considered. So my lord,
240 meters from National Highway and 165 meters from school.
Their affidavit also disclosed that the NOC is not given by the larger section of people. My lord.
No, it
larger,
is given. It is on the contrary. They have no objection to that.
Yes.
My lord.
You are only busy in protecting the interest of the citizens. While you were protecting this, they have given NOC.
My lord.
What is your request?
My lord, my contention is that, my lord, the larger section of people is against the.
See, we are in a court of evidence. In the sense, जो paper में लिखा होता है वो सुनते हैं.
My lord.
We go as per their affidavit. There is compliance with the Assam rules.
My lord,
The distance is
my lord,
distance is there.
my lord, the rule says that the NOC is to be taken from the panchayat. It's a panchayat area that has not been taken.
That anything else?
And there is a judgment of this honorable court, my lord, in division judgment that public good is to be given emphasis.
Correct. You unnecessarily are after these people. I don't know who are you.
My lord.
This is a PIL which should be disposed of or dismissed with cost.
My
This
lord.
has become, this is the third matter within 3 months. A similar matter. Only in your matter, the council is saying, in other 2 matters, the council is also saying. PIL is not a role of a mother-in-law. These are all mother-in-law's role. Then come out with prohibition policy if you are so averse to it. Otherwise, we have to look at the law. You say panchayat not given, there is a certificate given by panchayat.
Yes.
So we have to hear every type of argument here. Yes, you can argue, sir. We are not stopping you. We are only telling you.
My lord. My lord, their affidavit, my lord. Lordship may kindly have a look at their affidavit. Yesterday they have filed, my lord. And that affidavit.
Yesterday?
Close.
No, yesterday, 13th
Yesterday,
of
my lord.
September.
Today, on 27/9, 2020. The affidavit has been filed by the respondent number 2 and 3, my lord.
No, we don't have any affidavit. We don't have any such affidavit. Who is respondent number 2 and 3?
My lord, 2 is my lord. Commissioner,
party lordship.
Commissioner,
Oh, Commissioner.
Commissioner Secretary Excise Department. And then Commissioner Excise Department, 3, my lord.
Who are the advocates? These different advocates is a unique
lord,
system in the
Lordship,
name is
Excise Department, they have separate
Korobhi
counsel,
Soikia.
but I have filed on behalf of the Deputy Commissioner, Lordship.
Keep back at 2 o'clock. Call him. Come at 2 o'clock. We'll look into it.
My lord.
Call the learned counsel and call for the affidavit. Necessarily, these type of matters are pending. Next.
But in these matters, we have taken the steps, services awaited upon the respondents. my lord. So may come up after the vacation. In the meantime, let us see whether service come complete.
Next. IA for air supposed to be filed.
My lord, we got the particulars of the legal years just 2-3 days back, my lord. We'll be filing this application. Lordship may fix a date. after
You bring that IA day after tomorrow so that it can be disposed of and the matter can go ahead.
My lord.
Take a,
Continuing on that these days for quite some time.
take a sheet from my court master for early hearing,
My
for
lord.
listing. You should mention, I am mentioning, so that one step may be over.
My lord.
File it and bring it day after tomorrow.
My
On the
lord.
list. Rupam bhai, if he asks for a slip, please give him a slip for hearing. Next. Here service is awaited. You are there? Service is awaited, I think.
Lordship.
Service is incomplete.
Your Lordship, so far as the respondent number 5 and 6 is concerned, Your Lordship, the department counsel can represent Your Lordship. I will represent.
You will appear.
Yes, sir. For 5 and 6. President of the Ansari Panchayat and the Secretary of the Gaon Panchayat.
Because they have not been served as per the office report. Then file your reply.
Lordship, I am on behalf of respondent number 7 to 15, Your Lordship.
Whatever.
And we have to file affidavit.
File it affidavit.
Lordship.
Interim relief.
So the
to
matter will
continue.
be taken after action.
Interim relief to continue at the request of so and so. Next.
My lord, interim is there. Interim
That
order
will continue.
All right.
Very please, Lordship. Lordship, contempt application we have filed and the
Now
respondent
the
filed a reply.
affidavit is there.
Yes, Your Lordship, it's on record. One objection we have, Your Lordship, para 1, Your Lordship is fine. It's been filed by one.
Maybe, but he is also authorized officer of that office.
Yes, Lordship. There is a general power of attorney given by the.
EAG is a constitutional authority otherwise.
Yes,
Lordship, contempt delegation of power.
Maybe. We take it. What difference now? Something has been done in view of the affidavit filed.
Lordship, they have not said anything why they have not complied to it, Lordship. My only grievance was that I should be transferred on spouse gun to my wife's place. That was my only grievance, which this court has allowed. Passed an order saying that an order should be passed. Lordship, kindly take the order.
Page 16.
Yes, Your Lordship.
If I may read it slowly.
You read any. I will stop you where you should to see that the matter is over. You read, the petitioner has already completed around 4 years in Guwahati. We therefore dispose of the present writ petition, directing the Director General of Audit to consider the application of the petitioner for transfer
To any place in Uttar
to
Pradesh.
any place in Uttar Pradesh near so and so. Then
We
this
make it-
sentence is very important.
We make it very
We
clear.
make it clear that this consideration shall be subject to two things: the availability of vacancies, and also subject to fact that the rules and regulations governing this will permit such transfer.
And posting.
Now, if you read the affidavit, nothing remains.
Lordship, that stand, they have taken it prior to the, when the.
Whatever it may be, say transfer, there is no contempt as such. There is no willful disobedience. If you read the affidavit,
That was the whole thing, Lordship, when the writ petition was pending here, they have taken this stand, that I cannot be transferred.
naturally, then this court has not directed that no, you should be transferred only.
As per the rules. they
As
have-
per the rules, they have examined it. We are not examining the merits of this case. We are saying only willful disobedience is there or not. Article 215 read with section 12 of the contempt of court act 1971. Our jurisdiction ends there. You want to take advice from somebody?
Yes, sir.
Then tell me frankly. When do you want?
After vacation work.
Next.
Oblige, Your Lordship.
Mr. Mahanta, you take his advice. Now nothing remains. Item number?
Item number
25.
25, my lord. The report was called for, my lord. We have received the report, my lord, regarding the attendance of the respondent, my lord. We have received the report, my lord. However, my lord, today I am praying for a little adjournment, my lord.
Well, such report was also given during the contempt proceeding.
My lord,
Proceeding.
I'll submit the report.
To continue. Next.
But a date may be given. She is
Yes,
not
yes,
getting
date.
salary since 2006.
Date will be given. Mr. Das, I don't keep any matter without a date.
Oblige, lord.
Yes, steps are yet to be taken. Who is there in 26?
May I plead your lordships? Lordship, as per official dated 26/9/2022, neither AD card nor answered notice has been received from the sole respondent. But lordship, I am seeking apology for not taking step for dusty service. Your lordship may pleases to allow for taking step for dusty service.
Press notice to respondent. Justice service permitted. Returnable
Obliged.
after 4 weeks.
Obliged.
Give the date. Don't say 4 weeks. It should be holidays or we don't know. Huh? I will come at 2 o'clock.
I'm extremely sorry, my lord. I could not, I apology for that. Acapulco was supposed to appear, my lord. And on the last occasion, my lordship was pleased to direct the railway council to submit their affidavit. And I have not received any copy whether they have filed or not.
No, we have not filed, my lord. We are relying the affidavit filed in the single judge, my lord.
Yes, sir. Yes.
So my appeal is that, my lord, Lordship may take the matter after vacation because Mr. Borges is not in a position to apply to him. Obliged.
Yes, my lord, as per the affidavit, my lord, with the affidavit, the distance from the school is 165 meters and from national highway it is
240 meters.
45, my lord. My lord, the rule 83 of the access rule, Assam access rule says that it should be a reasonable distance. Should be a reasonable distance, and according to the petitioners, their version about the distance is not correct.
You can argue, we are not stopping you, you argue the matter. What is your content?
My lord, we have also filed a reply to the affidavit of respondent number 2 and 3, my lord. According to our stand, my lord, the distance from the school, it is about 50 meters, and from the national highway.
Now, we will certify that you or the DC.
My lord, there's, according to the petitioner, it's not correct. They are the local persons. And
Then it's a disputed question of fact, file a suit against them.
May I please your
You take your seat. He is arguing. So one is distance of the school.
My lord.
What is your second contention?
My lord, I have filed a reply affidavit, my lord, and in paragraph 4 we have said that the distance they have shown, my lord, it's not correct.
Okay.
And
any material to show that it is not correct?
My lord, they said that it's required.
No, any material with you? You are the petitioner. Any material?
My lord, matter is their local persons. They have
No. Any material is produced by you while making that.
No, my lord. No materials we have shown, my lord. Only we demand that it may be measured in presence of the petitioner or maybe an independent authority.
Okay. Anything else?
My lord,
which is the third content?
Yes, my lord. We are relying, my lord, to judgment of this honorable court, my lord. In paragraph 9 of this judgment says that it should be, my lord, right to have a license of liquor shop is not a matter of right. It should be public good is to be considered.
Yes, we understand. We agree with it.
My lord.
That is always so.
My lord.
It is not a good habit. We know it. But when it is concerned in a rule of law, the rule will prevail. So there is an Assam rule,
my lord,
which were amended in 2022 as per their affidavit. Therefore, we will have to look into whether it is as per the rules or not. There is no prohibition policy in Assam.
My lord,
which is the judgment that you are relying upon?
My lord, 2002 2 GLT 292, my lord.
2002
2 GLT 292.
292. Any paragraph?
My lord, paragraph 9.
Okay. Then what is next?
My lord, 9, my lord, I am reading, my lord. All the aforesaid facts have been mentioned in this case simply for the reason to emphasize that to get a license for running a retail shop of IMFL is not a matter of right. Not only for the issuance of the license, the authorities are to comply with the provisions of the Assam Excise Act 19.
That is what we are telling you, that everybody who wants this license is bound to follow. The state also is bound to rigorously implement that law. That you are absolutely correct. Anything else?
My lord, only my lord point is, my lord, they are saying that it is within the permissible limit, permissible distance.
Yes.
But according to the petitioner,
That you have told us. Any other contention?
my lord, that is
Heard Mr. A.R. Sikar. For the petitioner, Mr. Bhattacharya, for orders day after tomorrow.